Hey, what's up? I'm here to give you a 5-minute breakdown on why the 7th Circuit Court of Appeals on Christmas Eve affirmed the dismissal of Donald Trump's lawsuit challenging the elector selection process in Wisconsin, okay? So I've got some images that are going to pop up on the screen. The full opinion is here in the window. If you want to read the full opinion for yourself, it's only 11 pages. You can check it out in the description below. There is a link to the document and you can read everything, but I'm going to hit you with the most important parts of the document right here. So the first section is questioning what actually happened. On November 3rd, the United States held its 2020 presidential election. The final tally in Wisconsin showed that Joseph R. Biden Jr. won the state by 20,682 votes. On November 30th, the Wisconsin Elections Commission certified the results. The governor signed an accompanying certification. Wisconsin notified the National Archives that it had selected Biden's 10 electors to represent the state in the Electoral College. 2 days later, the president brought this lawsuit challenging certain procedures Wisconsin had used in conducting the election. The president alleged that the procedures violated the Electors Clause of the U.S. Constitution. Now, just a very quick point on this, that 2 days later becomes very, very important as the lawsuit goes on. They are saying basically, in no uncertain terms, Trump waited too long. They did say that even if he had not, or even if they had gone through the merits, rather than saying he waited too long, he still would have failed. However, the timing of these lawsuits has become a hot point of contention in all of them across all levels of state and federal judicial branches, okay? So, to implement the obligation imposed by the Electors Clause, and remember, Trump is challenging under the Electors Clause, Wisconsin's legislature has directed that the state's electors be appointed by general ballot at the general election for choosing the president and vice president of the United States. It is further assigned responsibility for the administration of laws relating to elections and election campaigns to the commission, the Election Commission in Wisconsin. Municipalities run the election, and each municipality's own clerk has charge and supervision of elections and registration in the municipality. This challenge is over the Electors Clause and whether or not changes made by the Wisconsin Elections Commission and the local clerks and municipalities can, in fact, invalidate the votes that were counted in Wisconsin as part of its general election procedure. Trump's main complaint here is that they basically usurped legislative authority at the local or administrative level through the Election Commission and the county clerks in implementing different policies and procedures than what was prescribed specifically by the state legislature. We begin as we must by assessing whether the president has presented a case or controversy over which we have jurisdiction. The inquiry turns on the doctrine of standing, and more specifically, whether the president has alleged an injury traceable to the actions of the defendants and capable of being redressed by a favorable judicial ruling. The district court answered the question in the president's favor. We do too. Standing is a three-pronged question. The first question is there an injury? The second, is that injury traceable to the defendant? And third, is the court able to grant relief on that? In short summary, this court decided yes for all three over on the relief question. It was a little bit more of a discussion about whether they could grant the specific release the president wanted, which was to undo the results of the election and award the electors in his favor. They said no, but that doesn't preclude them from having the ability to redress it by removing the electors and still allowing the legislature to send a new batch of electors. Okay, so that's how they got to standing. Number 4, we also conclude that the president's complaint presents a federal question, despite its anchoring in alleged violations of state law. We saw this in some other cases where basically they said, look, these are state law violations. You got to take it up with the state Supreme Court. Remember this point when we get to the end, because it's a little bit of a confusing mixed signal from the Court of Appeals. The 11th Amendment and principles of federalism bar federal courts from directing state officials to follow state law, but we can decide whether their interpretation of state law violated a provision of the federal Constitution. Here, the Electors Clause. This distinction alleviates any federalism concerns that might otherwise preclude our consideration of the president's claims. So they say they do have the authority to hear the claims under Article 3 of the U.S. Constitution, specifically related to the Electors Clause in Article 2. Okay, allowing the president to raise his arguments at this late date after Wisconsin has tallied the votes and certified the election outcome would impose unquestionable harm on the defendants and the state's voters, many of whom cast ballots in reliance on the guidance, procedures, and practices that the president challenges here. The president's delay alone is enough to warrant affirming the district court's judgment. That is, affirming the dismissal of President Trump's case in Wisconsin. So they did go ahead and basically use what's called a laches, the doctrine of laches, and that is to say that once you bring a lawsuit and it is too late to raise the claims such that it would overtly prejudice the other party, then the doctrine of laches comes in. It's like a statute of limitations. It says, sorry, too late. You brought the claim too late. And they have argued throughout this opinion that Trump should have brought the claims very far in advance of the election. Of course, this raises the ultimate question. How can you know that you will be injured by what's going on until the injury actually takes place? It's impossible to actually know that you will definitely be injured. And one of the problems we've seen, at least in other states, is that they did bring these claims and those claims were ignored for lack of an injury at the time. Finally, this is the conclusion of the lawsuit. We confine our conclusions to applications of the Electors Clause. We are not the ultimate authority on Wisconsin law. That responsibility rests with the state Supreme Court. Put another way, the errors that the president alleges occurred in the commission's exercise of its authority are in the main matters of state law. They belong then in the state courts where the president had an opportunity to raise his concerns. Indeed, the Wisconsin Supreme Court rejected his claims regarding the guidance on indefinitely confined voters, see Trump versus Biden, 2020, and declined to reach the rest of his arguments on the grounds of laches, the same thing. For our part, all we need to say is that even on a broad reading of the Electors Clause, Wisconsin lawfully appointed its electors in the manner directed by the legislature. So that is where they ended up. For these reasons, we affirm that is why this case has been dismissed according to the Seventh Circuit. We have long-standing and still unanswered questions. One question we do have answered is that the president himself does apparently have standing to bring these claims in federal court, which is nice to know since states don't, other candidates apparently don't, electors don't. A lot of people don't have standing, but apparently the president does, at least in the Seventh Circuit, have standing. And to bring it under the Electors Clause. Unfortunately, the doctrine of laches is still the sort of way for the court to not hear this case. They said, look, even, it doesn't really matter because it's too late. But at least in fairness to the Seventh Circuit Court, they finally did say, even if we ignore the fact that it was late, we look at the challenges raised and we say that Donald Trump's suit would not pass muster. And the main reason for that was stated earlier on in the clips that I posted, and it was that the state legislature of Wisconsin, and remember, these are all state-specific things, did go ahead and grant authority on how to manage these elections to that state election commission, and that is one of the main reasons why this was allowed to go on. At least in regards to the Seventh Circuit and the state of Wisconsin, they say that under the Electors Clause, the state legislature did choose the electors by first designating to the state election commission how to implement the election and to give them some discretion there. And more importantly, I think one of the big problems with all of these lawsuits and how they're framed under the Electors Clause is once the state legislature certifies the results, then the state legislature has chosen the electors under the Electors Clause. And that poses an interesting problem. Of course, I'm not saying that that's entirely the right answer, because we saw in other instances where elections are not allowed to be challenged until the legislature has certified the results, which creates a confusing problem. And it's why election law is so messy. It all has to happen very quickly, and there are timelines both before and after certification that apparently need to be followed, but the courts have a lot of flexibility to deny all of it. Okay, so I lied. It was more like 10 minutes, but that is the whole thing. We'll talk to you then. I hope you enjoyed this. If you find this informative, like, subscribe, share, let people know what's going on in the law around them. All right, thanks a bunch. Peace. Peace.